Ikoyi, Lagos State, to fraudulently effect transfer of title of property situated at number 6 2nd Avenue, Ikoyi, Lagos, belonging to Nigerian Army Properties Limited, to Julian Investment and Estate Company Limited. Elements of offense. The elements of the charge in count 10 are as follows: that the accused senior officer is subject to service law. 2, that he was the group managing director / chief executive officer of Nigerian Army Properties Limited as at 3rd May 2020. 3, that he conspired with Mr. Yusuf Abubakar Abdullahi, now at large, to forge a document titled Deeds of Agreement, which purportedly transferred title of property situated at number 6 2nd Avenue.
Deed of assignment, sir.
Deed of assignment, correction. Deed of assignment, correction, which purportedly transferred title of property situated at number 6 2nd Avenue, Ikoyi, Lagos, belonging to Nigerian Army Properties Limited, to Julian Investment and Estate Company Limited. Gleaning from the advice of the learned judge advocate in this respect, and the glaring inability of the prosecution to lead evidence of the alleged conspiracy to forge, this special court-martial holds that the prosecution was unable to prove the charge. The court therefore finds the accused senior officer, Major General U.M. Mohammed, N/8656, not guilty of count 10. Count 11. Statement of offense. Committing a civil offense contrary to Section 114, subsection 1 of the Armed Forces Act, Cap A20, Laws of the Federation of Nigeria 2004. That is to say, forgery contrary to Section 1, subsection 2, subsection C of the Miscellaneous Offences Act, Cap M17, Laws of the Federation of Nigeria 2004, and punishable under Section 1, subsection 2 of the Miscellaneous Offences Act, Cap M17, Laws of the Federation of Nigeria 2004. Particulars of offense. In that you, Major General U.M. Mohammed, N/8656, on 3rd May 2020, while serving as a group managing director / executive vice chairman of Nigerian Army Properties Limited, and one Mr. Yusuf Abubakar Abdullahi, now at large, forged a document titled Deed of Assignment, which purportedly transferred title of property situated at number 6 2nd Avenue, Ikoyi, Lagos, belonging to Nigerian Army Properties Limited, to Julian Investment and Estate Company Limited. Elements of the offense. The elements of the charge in count 11 are as follows: 1, that the accused senior officer is subject to service law. 2, that he was the group managing director / executive vice chairman of Nigerian Army Properties Limited, correction, chief executive officer of Nigerian Army Properties Limited as at 3rd May 2020. 3, that he forged a document titled Deed of Assignment, which purportedly transferred title of property situated at number 6 2nd Avenue, Ikoyi, Lagos, belonging to Nigerian Army Properties Limited, to Julian Investment and Estate Company Limited. This special court-martial aligns with the learned judge advocate on the presumption of legitimacy, which the document titled Deed of Assignment between the Nigerian Army Properties Limited and Julian Investment and Estate Company Limited enjoys, by virtue of the provision of Section 145, subsection 2, and Section 167, sub C of the Evidence Act 2011. The prosecution having failed to lead evidence to rebut the presumed legitimacy and establish forgery beyond reasonable doubt as mandatorily required, the allegation against the accused senior officer will suffer the same fate as in count 10. The court holds that the prosecution has not proved count 11. The accused senior officer, Major General U.M. Mohammed, N/8656, is consequently not found guilty in count 11. Found not guilty in count 11. Now to count 12. Statement of offense. Conduct to the prejudice of service discipline, punishable under Section 103, subsection 1 of the Armed Forces Act Cap A20, Laws of the Federation of Nigeria 2004. Particulars of offense. In that you, Major General U.M. Mohammed, N/8656, on or about 30 July 2021, while not serving as the Group Managing Director / Executive Vice Chairman of Nigerian Army Properties Limited, sold property of the Nigerian Army Properties Limited, situated at number 6 Marina, Ikoyi, Lagos, with certificate of occupancy number D004751, registered as number 20 at page 20 in volume 154 at Federal Lands Registry, Ikoyi, Lagos State, to Land Sea Construction and Engineering Limited for the sum of 200 million naira only. Elements of the offense. The elements of the charge in count 12 are as follows: that the accused senior officer is subject to service law. 2. That as at 30 July 2021, he was not serving at the Nigerian Army Properties Limited. 3. That the property situated at number 6 Marina, Lagos, with certificate of occupancy number D004751, registered as number 20 at page 20 in volume 154 at Federal Lands Registry, belongs to Nigerian Army Properties Limited. 4. That the accused senior officer sold the property to Land Sea Construction and Engineering Limited for the sum of 200 million naira only. And 5. That the sale of the property, when he was no longer serving at the Nigerian Army Properties Limited, was a conduct prejudicial to good order and military discipline. The contentious issue in this charge is the authenticity or otherwise of Exhibit P12 Bravo, that is the deed of assignment, transferring transferring the property at number 6 Marina, Lagos, from Nigerian Army Properties Limited to Land Sea Construction and Engineering Limited. The Special Court Martial noted the attempt by the accused senior officer to declare the document a forgery by disclaiming the signature attributed to him on the document. The court considered all the evidence led by the prosecution and the defense on this count. Relying on the judicial authorities posited by the learned judge advocate, this special court martial comes to the conclusion that it is not bound to accept the evidence and conclusion of an expert as being sacrosanct. The decision on matters like genuineness of signature lies squarely on the court. The court can reach a conclusion on this matter by evaluating all evidences on the matter, including the evidence of the expert. The special court martial has therefore evaluated the evidence in this regard, including the evidence of the expert, that is, the manner he was commissioned to carry out the analysis, the non-demonstration before the court on how he arrived at his conclusion, and his overall demeanor, all of which are relevant to the weight to be attached to his opinion. The court, therefore, believes that the accused senior officer signed Exhibit P12 Bravo, that's the deed of assignment, transferring ownership of the property situated at number 6 Marina, Lagos, from Nigerian Army Properties Limited, when he was no longer serving at the Nigerian Army Properties Limited. The court, therefore, holds that his conduct was prejudicial to good order and military discipline. Arising from the foregoing, the accused senior officer, Major General U.M. Mohammed, N/H656, is thus found guilty as charged on count 12. Count 13. Statement of offense. Committing a civil offense by virtue of Section 114, subsection 1 of the Armed Forces Act, Cap A20, Laws of the Federation of Nigeria, 2004. That is to say, theft, contrary to Section 286, subsection 1 of the Penal Code, Laws of Northern Nigeria, 1963, Cap 89, and punishable under Section 287 of the Penal Code, Laws of Northern Nigeria, 1963, Cap 89. Particulars of offense. In that you, Major General U.M. Mohammed, N/H656, on 22nd August 2019, while serving as the Group Managing Director / Executive Vice Chairman of Nigerian Army Properties Limited, dishonestly took the sum of 74 million naira only from Nigerian Army Properties Limited Zenith Bank account number 101-580-5332, domiciled at 63 Osuma Street, Maitama, Abuja, to DISA Nigerian Limited, Zenith Bank account number 101-2426842, from the sum of 75 million naira only, paid by Lagos Metropolitan Area Transport Authority through Lagos State Government for use of part of Nigerian Army Properties Limited land situated at number 6 Marina, Victoria Island, Lagos. Elements of the offense. The elements of the charge in count 13 are as follows. 1. That the accused senior officer is subject to service law. 2. That the Lagos Metropolitan Transport Authority, through the Lagos State Government, paid the sum of 75 million naira only to Nigerian Army. I take that again. That the Lagos Metropolitan Transport Authority paid the sum of 75 million naira only through the Lagos State Government to Nigerian Army Properties Limited for the use of its land situated at number 6 Marina, Victoria Island, Lagos. 3. That the money was paid into Nigerian Army Properties Limited, Zenith Bank account number 101-580-5332, domiciled at 63 Osuma Street, Maitama, Abuja. 4. That the accused senior officer was serving at Nigerian Army Properties Limited as the Group Managing Director / Executive Vice Chairman as at 22nd August 2019. 5. That on or about 22nd August 2019, he took the sum of 74 million naira only, paid from the 75 million naira only, paid by the Lagos Metropolitan Transport Authority through Lagos State Government to DISA Nigerian Limited Zenith Bank account number 101-242-6842. And 5. That the money was dishonestly taken. The evidence led on this count by Mr. Oluwaseun Shonoike, Mrs. Oluwaseun Shonoike, prosecution witness 11 in this case, and exhibit P6 series tendered before this court showed copiously and coherently how negotiations between the Lagos Metropolitan Transport Authority and the Nigerian Army Properties Limited culminated in the payment of 75 million naira only from the Lagos Metropolitan Transport Authority to Nigerian Army Properties Limited. The money was for the lease of a parcel of land at number 6 Marina, Lagos, belonging to Nigerian Army Properties Limited for the Lagos Blue Line Rail project. The money was paid to Nigerian Army Properties Limited, account number 101-580-5332 at Zenith Bank. The statement of the account was tendered before this court as Exhibit P7 Echo. Out of the 75 million naira only paid to Nigerian Army Properties Limited for this transaction, a total of 74 million naira only was transferred to DISA Nigerian Limited account number 101-242-6842, as shown by Exhibit P7 Gov before this court. The justification for this transfer was said to be debt repayment. This special court-martial, in the circumstance, finds this defense incredible because of the fact that no evidence was led to show the existence of a lender-borrower relationship between Nigerian Army Properties Limited and DISA Nigerian Limited. The approval for such a loan, the tenor, as well as terms and conditions of that loan. This is just an empty assertion by the defense to cover up the theft of 74 million naira only from Nigerian Army Properties Limited. The court therefore holds that the prosecution proved this case of theft against the accused senior officer beyond reasonable doubt. The accused senior officer, Major General U.M. Mohammed, N/H656, is therefore found guilty as charged in count 13. Count 14, count 15, count 16, count 17, and count 18 will be taken together. These counts were all charges of criminal misappropriation brought under Section 308 of the Penal Code, Laws of Northern Nigeria, 1963, Cap 89. The counts are all alleging the dishonest misappropriation of various sums of money from FCCL Napil Properties Limited, Access Bank, number 076-991-1478, being monies paid by subscribers and Central Bank of Nigeria Staff Multipurpose Cooperative Society for the Asokoro Hills Smart City Project. The testimony of Sani Danjuma, who was prosecution witness 19 before this court, and Exhibit P16 series tendered during the course of the trial through him depicts clearly how a total sum of 2,500,000,000 naira only was paid by the Central Bank of Nigeria Staff Multipurpose Cooperative Society to FCCL Napil Properties, of which the accused senior officer was a director and the chairman. The testimony of one Fatima Ajibade, who appeared before this court as prosecution witness 23 from Access Bank PLC, shows that various sums of monies were hasted from the accounts to various entities for reasons not connected with the development of the Asokoro Hills Smart City Project. The defense of the accused senior officer is that he was remote from the account and had no dominion or control on the transaction of FCCL Napil at Access Bank. The court notes that in the circumstances, as a director and chairman of FCCL Napil Properties Limited, and the transfer of various sums of money took place over time, the defense of not being in control does not avail the accused senior officer. The court also notes the advice of the learned judge advocate on how companies operate and holds that this defense is not tenable. The accused senior officer is therefore found guilty as charged on count 14, count 15, count 16, and count 18 as charged. In consequence, therefore, and in accordance with Rules of Procedure 43, sub 1 of the Rules of Procedure Army 1972, the alternative counts to count 14, count 15, count 16, and count 18 will not be considered any further before the special court-martial. That takes us to count 17. The vital element of this offense is that the accused senior officer withdrew the sum of 750 million naira only from FCCL Napil Properties Limited, Access Bank account number 076-991-1478, being monies paid by subscribers and CBN Staff Multipurpose Cooperative Society for Asokoro Hills Smart City Project. No evidence was led, whether oral or documentary, to prove such withdrawal. Although the prosecution tendered Exhibit P16 Gulf, being the statement of account of FCCL Napil Properties Limited, Access Bank account number 07991-1478, from where the monies were allegedly withdrawn, the prosecution did not show the details or particulars of the withdrawal. It is not the duty of this special court-martial to go searching with a fine-tooth comb for evidence. The prosecution was unable or simply failed to bring out evidence clearly to the count. The special court-martial, therefore, holds that the prosecution failed to prove a vital ingredient of the charge. Count 17, therefore, fails. In consequence, therefore, the accused senior officer, Major General U.M. Mohammed, is found not guilty of count 17 as charged. The alternative count to count 17 is also predicated on the above element of withdrawal of the sum of 750 million naira only, which the prosecution has failed to prove. The alternative to count 17 is therefore not given any further consideration by this court. Distinguished members of this court, the prosecution and defense team, members of the press, gentlemen, these are the findings of this special court-martial in the case of the Nigerian Army versus Major General U.M. Mohammed N/8656. Just before I conclude, it is imperative to inform the accused senior officer of his right in line with Rule 71, Sub 5 and Sub B of Rules of Procedure Army 1972, which provides that an accused, if the findings of a charge is guilty, may address the court in mitigation of punishment before the court deliberates on the sentence. I thank you.